Welcome to Module 4, Part 3, comprised of Chapter 9 and 10. In these two chapters, you will dive into the business considerations for omnichannel retailers. We will also start by discussing the complex ethical and legal concerns for the omnichannel retailer in Chapter 9. In Chapter 10, we will explore consumer-facing trends such as augmented reality and virtual reality integration, collaboration, consumption, and visual search. Chapter 9, Ethical and Legal Issues in Omnichannel Retailing. In this chapter, you will learn how to apply current sales tax regulations for the omnichannel retailer. Also, how to assess the contemporary ethical and legal issues involved in the omnichannel retailing. Then we will discuss the fundamental concepts related to the consumer privacy, consumer data rights, and relevant regulations. Next, we will talk about the various forms of intellectual property and justify how to protect intellectual property in the fashion business within the context of omnichannel retailing. Last, we will evaluate how social influencers should comply with the FTC influencer marketing regulations. So first, let's talk about the ethical and legal issues and the business considerations in omnichannel retailing. So invented in 1960s, the internet has established as an internet-connected network among government researchers to share information, and where trust is built as an assumption. However, as the internet spread out, nowadays, internet has become an any-to-any network, and so you may run into someone or met someone online, but you don't know if he or she is actually the person they claim to be. And therefore, the internet we are enjoying right now has that inherent vulnerability to suffer from the computer virus attacks, credit card fraud, black markets for the personal data. And so there's new business model involved in the omnichannel retailing that can be protected under the intellectual property rights as well. That's why you will need to learn how to protect a new business and the various intellectual property protections you can use. And then the disruptive effect of e-commerce has already created for the local retailers and state governments, especially for the sales tax collections. Therefore, we're going to first start to talk about the tax. So there have been fight between the state government and then with the online retailers. So there has been a changing landscape regarding to the sales tax regulation in the past 2 decades. So let me ask you a question. What's the sales tax rate in Texas or wherever your hometown is? So in Texas it's 8.25%. And then recall your online shopping experience. Did you have an experience that you did not pay the sales tax when you shop online? Next time, pay attention to your transaction when you buy something, and then you may notice sometimes you pay for sales tax, sometimes you don't. And then in the following slides, I'm going to explain why you have to pay and then why you did not pay. So a sales tax is exclusively collected by a retailer during the final sale of a good or service. is paid by the end consumers and is considered as one of the major revenue sources for the state government. And in 1992, Supreme Court's case, Quill Corp versus North Dakota, determined that the state could not collect the sales tax on goods sold over the internet unless the seller had a physical presence in that state. Okay, so that was 1992. So fast forward 20 years later, the states, two biggest states, California and Texas states, brought Amazon to courts and then made Amazon collect sales tax for these states. And in 2018, actually, state government of South Dakota brought the Wayfair to the court. They sued all the way to the Supreme Court. And then in that year, the U.S. Supreme Court stated that individual states could require online sellers to collect a state sales tax on their sales if the retailer has a physical or economic nexus to in that state. So what are physical versus economical nexus means? So physical nexus means a retailer has a physical presence in that state, whether it is an online office, store, or a warehouse. And then, so this is the Supreme Court also in this case established a new rule, which is so-called economic nexus, which exists when a retailer earns above a sale or revenue threshold in a specific state. For example, in California and Texas, if you sell over $500K a year for the out-of-state retailers, they will consider you as has established the economic nexus, and then therefore you will need to start to collect sales tax from for the state government. So this approach is set up to protect small retailers not to overwhelm from the burden of a sales tax. But at the same time, once you achieve a certain economic level, then the Supreme Court thinks that you should be able to afford to collect the sales tax for the state government. So as of January 2024, there are 46 states plus Washington, D.C. that has the economic nexus rules. 4 states do not have any economic nexus laws. They are Oregon, New Hampshire, Montana, and Delaware. They don't have the nexus law, economic nexus law, because these states do not have a state sales tax in the first place. Table 11.4. Table 9.4 is the table that lists the top 10 most populated states in the United States and then their economic nexus. As you can see here, both California and Texas set up the 500,000, 500K as the threshold. Florida set up as 100K as the threshold. New York is also 500,000 as well. And then also when is the measurement date, and then when do they retailer need to register and to start to collect the sales tax. So in Texas, it is 500,000, and then when the retailer needs to register, once it exceeded threshold, will be the first day of the 4th month after the month in which the seller exceeded the safe harbor threshold, which is the safe harbor threshold. So the state government of Texas give the online retailers 3 months of time to work on setting up the tax collection mechanism. Okay, so now we have talked about the changing landscape of online sales tax. Next, business considerations, which is very important, and in the regulation part is the consumer data and privacy. So according to market research, 87% of the consumers said they would not do business with a company if they had concerns with its security practices. And then over 70% said they would stop doing business with a company if it gave away sensitive data without their permission. So as data is very important for retailers to offer omni-channel services. And so retailers may use the following personal data to help with developing the practices, and including consumers' location data, payment card data, cell phone data, Instagram accounts, IP address, browsing, shopping history, etc. And then actually this is one of the cover of Time magazine, and then saying that with the data economy, individual consumers' data is a valuable asset for sale. And so before we talk further, I would like to ask you some questions so you can find out what kind of privacy, consumer privacy segments do you belong to. So this is from the Columbia professor Weston, and first question asks, consumers nowadays have lost all control over how personal information is collected and used by company. If you strongly disagree, anchor as 1, and then strongly agree is 6. So write down the number that you for your response to this question. If you think consumers have lost all control over how personal information is collected and used by company, please rank your response anchor from 1, strongly disagree, to 6, strongly agree. Okay, write down the number. Next question is, most businesses handle the personal information they collect about consumers in the proper and confidential way. Again, 1, strongly disagree, 6, strongly agree. Number 3, existing laws and organizational practices provide a reasonable level of protection for consumer privacy today. 1, strongly disagree, and 6, strongly agree. Okay, so I hope you have write down your answer to these 3 questions. In the following slides, I'm going to talk about how Wisdom classified the consumer into 3 different groups using these 3 questions. So, first of all, if your answer is from 4 to 6 for the first question, and then you answer 1 to 3 for the second and third question, then you are a privacy fundamentalist. Okay, and the privacy fundamentalists are the consumers that who are very suspicious of companies, how they would deal with their data, and they are not willing to trade their data for any like benefits or discounts. And then if you are, your answer to the first question is from 1 to 3, any one of them. And then for the question 2 and 3 are falling to 4 to 6, then you are the privacy unconcerned group. So basically for these types of a customer, they don't think privacy is an important or like a serious issue for them. And then so therefore they are not concerned about their privacy. And for those of you who are not belong to the privacy fundamental group and unconcerned group, you are like me, fall into the third group called privacy pragmatist group. So privacy pragmatist group is somewhere between the fundamentalist and unconcerned group. And then this group of consumers thinks privacy is important, but they are willing to trade their personal information with some kind of benefit or credits or discount. So in 2002, Harris Interactive, which is a market research company, they have done a U.S. national survey, and what they found is 15% in the U.S. population belong to the privacy unconcerned group, and then 25% belong to the fundamentalist group, and then a majority of 55% belong to the privacy pragmatist group. In 2015, I did a study as also collecting data from the U.S. national population. In that study, I found the major group still belong to the privacy pragmatist group, and is as high as over 71%. And then the privacy fundamental group has shrunk to 15%, and then privacy unconcerned group is around 13.7%. However, fast forward to 2021, a little bit entered the like a pandemic, and then I conducted a survey on Amazon MTurk, and then I found out on the MTurk population, they actually have over 45% belong to the privacy fundamentalist group. And then the pragmatist group is the second biggest group, counts as 32%, and then unconcerned groups rise to 22%. So that's an interesting shift that more people now, like according to the 2021 data, now understand how valuable their data are, and they may not want to trade information. But at the same time, there are also rising group that thinks privacy is not important to them, and it is around 1/5 of the general population. So now you have learned about your own privacy segment. Then next we will talk about how the major players and big companies are treating the information privacy and security. And so first of all, let's have a definition correct. So information privacy refers to consumers' ability to control how and to what extent their personal information is to be transmitted to others. So the control and then what extent is very important when we come to define the information privacy. And so there is a term called the privacy paradox that has been discussed in the academia because that is the idea that the users state the preference that they care about privacy, but then they do not always match their actual behavior and choices. In other terms, they say they care about the privacy, but when it comes to the cookie setting, like do you accept all the cookies, and then they will say yes without reading what exactly are the information that the cookies collected from them. And so these are called the privacy paradox. And so to overcome this problem, but a lot of time, if you interview consumer, they will say, those terminology in the privacy policy is too legal and I couldn't understand. And so I don't want to spend time to read those like thousands of words in the tiny little gray font. While I would just want to buy something, right? So, because of this difficulty for consumer to individually recognize and accept these privacy settings, Apple actually started a so-called privacy nutrition labels in their App Store. And as figure 9.1 gives you an example of it. And then the aims to put policies in the plain terms for the users, and so that before a consumer to download an app, they will know what kind of information the app developer or publishers collect the data from them. So including their financial information, purchase information, and then the things that link to like their personal identification, and then some other data that they are anonymous and do not link to the consumer. So consumer will be able to make more informed choice before they decide to download the app. And so you have heard me to talk about a term called the personal identifier data. So personal identifiable information is defined as any representation of information that permits the identity of an individual to whom the information applies to be reasonably inferred by either direct or indirect means. So the direct means for the PII, including names, your address, your social security number or other identification number or code, telephone number, email address, etc. The indirect means maybe identify a specific individual in conjunction with other data elements. For example, if you live in a small town, and then you are the only one in your town comes to study retail management at Texas Tech University. Then by using the data from someone in your age group and then goes to retail management in Texas Tech, then they will be able to identify you as a specific individual. So that's called the indirect means. So as you can see, the concept of personal identifiable information has diminished its relevance and meaning because it becomes easier and easier to associate an individual with a digital device, and then also if you merge data together by cross-reference several indicators, you will be able to find out and identify a specific individual. So there are a lot of law professionals has argued that in the era of big data, claiming that any data is anonymous is meaningless. So now you understand the definition of personal data and data rights. We have to discuss a good question is who owns consumer data? Do you think is the consumer, you owns your data, or the retailers collect the data owns your data? Okay, so to give you some background on the privacy law in the U.S., the privacy law has been sectoral, which means your DVD rentings, like a history is protected, your education records is protected, and then your medical history is protected, but then they are all protected in the different aspect. And then so there's no comprehensive privacy law in the United States covers your browsing data, your IP address, your financial information, this kind of data if they merge it together. So the company, third party, and data broker, they are all collecting a consumer's online browsing history and shopping history. Do they own your purchasing, browsing data? And then more importantly, can they sell your data so that other people can make money from that? So in 2016, I published a paper and to survey U.S. consumers' attitude towards the data broker and third-party advertiser. And then especially for the loyalty program consumers, because retailer has more their data when someone joined the loyalty program. However, I want to know that if your consumer actually cares about their personal information like their name, geographic location, online browsing history, income level, financial information, health information, they care about like how they will their willingness to share with third-party advertiser versus data broker. So for data broker are the ones that who collect the data and then sell it as their main business. And so as you can see here, the t-test, two-sample t-test shows there's a significant difference that consumer may have a higher willingness to share with third-party advertisers to receive the personalized ads towards them. However, they have a much lower willingness to share their data with the data broker. So after 10 years of study, finally, California, the state has pushed out the California Consumer Privacy Act, and then they made the California the first state in the U.S. to offer a more comprehensive protection on consumer data rights. So if you go to a website, you see there's a Californian, like a privacy rights, or there's a tab, do not sell my data. Those tabs are designed and they are there specifically under the requirements of the CCPA. And then in 2018, European Union also pushed a general data protection regulation. It was put into place to protect consumers in the EU by giving them more control over their personal data in the form of subjective data rights. So the term is called subjective data rights. Subject is the individuals. So my master students and I did a thesis, and then because this is a European law, and then does Google or Meta or Walmart, these kind of global business, they are not, by law, they are not required to offer the GDPR, the 8 different subject data rights, including like the consumer will be able to ask the retailer to delete those data they collect from them, to correct the data, and then also limited using AI to make a decision about them. So for these data rights that EU gave to consumers, US based retailer do not need to give this right to the US consumer, even though they are giving them to the EU. So the study found that the US consumers feel treated unfairly if a company were giving the 8 different data rights to the European consumer and then not to the US consumer. So therefore, the result suggestions from this study is to recommend the US retailers voluntarily to offer the data rights to both the EU and the American consumers. So now we have talked about the definition of information, privacy, and regulation. Next, we will talk about the Children's Privacy Protection Act. So in the US, children is defined as children under 13 years old. So once you are over 13, you are on your own, okay? And so if your business collect personal information such as full name, physical address, email or video chat ID, IP address, or photos, etc. from children under 13, you have to get the parental confirmation to consent when you collect their data. So COPPA is the name of the law, and FTC, the Federal Trade Commission, is the agency that in charge of enforcement of this act. So they recommend the following 6 steps to comply with the law. Step 1, you need to determine if your company is a website or online service that collects the personal information from children under 13. Second, you want to post a privacy policy that complies with COPPA. Third, you want to notify the parents directly before collecting personal information from their children. Fourth, you want to get the parents' verifiable consent before collecting personal information from their kids. Step 5 is you want to honor parents' ongoing rights with respect to personal information collected from their kids. Step 6 is implementing reasonable procedures to protect the security of kids' personal information. So in the following slides, this is how Google emphasizes privacy to enhance customer trust. So I'm going to upload this video in the Blackboard and then you can watch it.
Let's talk about how you can deliver better ads while earning people's trust.
So this is a 3.5, around like almost 4 minutes video, and I hope you can see like how Google promotes the privacy strategy and while building the brand trust. So now we wrap up the information privacy regulations and strategies to protect the consumer privacy. Next, we will talk about the regulation in the social media marketing. So social media marketing regulations is considered, so social media influencer marketing is considered as a type of endorsement advertisement. And the influencer must clearly and obviously disclose their material connections or their connection to the brand they are promoting. So the material connection can be a personal, family, friends, employee, or financial relationship. And then no matter if the post is paid or sponsored, the influencer must disclose the relationship in the description or verbally in the video. So FTC has been updating its guidelines in the link here on how social influencers should disclose the material connections and make it obvious to their followers. And so in the following, we will talk about when, how, and to make these disclosure obvious. So when to disclose, as long as an influencer has any financial, employment, personal, or family relationship with a brand, they should disclose the material connection. Second, how to disclose, you need to make it obvious and then hard to miss. And third, the forms of the disclosure may including thanks to my favorite fashion brand for the free products, or you can have hashtag like a hashtag the brand name like my favorite fashion partner, and then hashtag ads, sponsored, or advertisement, and then but do not to put like a vague terms like a thank you or ambassador, or confusing acronym like SP, SPON, or collab, like these as a form of disclosure. So you need to make it obvious and hard to miss is the main principle here. Okay, so now we have wrapped up the privacy and the social media marketing. Next, we will talk about the intellectual property rights. So, intellectual property protections are related to the e-commerce, including the different formats, and then the intellectual property IP refers to creations of the mind, everything from works of art to inventions, computer programs to trademark and other commercial signs fall under the intellectual property protection. So in this chapter, we are going to talk about three main types of protection in the IP. So first is trademark, the second is patent, the third is copyright. And remember, the goal of the intellectual property law is to balance two competing interests, public and private, because the law gives the inventor or the owner of the intellectual property a certain year of exclusive property right to enforce this property, but then after that years, then this intellectual property goes into the public domain and anyone can use them. So in the United States, the USPTO, U.S. Patent and Trademark Office, is the agency responsible for granting the U.S. patent and registering trademarks. The U.S. Copyright Office in charge of the copyright issue. So first, trademark. Trademark is any word, name, symbol, design, or color capable of distinguish the goods or services of a business from others. The government registration of trademark confers exclusive legal right to its use. So in the world, there are two main systems, and then the US is the unicorn because most of the world use the first to file system, which means whoever registers a trademark first has the right, regardless whether they were first to use the mark. Okay, China, Japan, European countries, and Germany, they all use a first-to-file system, while US use the first-to-use system. First-use system refer to the party gains the rights in the trademark by using it in the commerce first. Of course, it will need to provide the evidence and to prove in the court that you are the first in the market to utilize this trademark. So USPTO has a trademark search database. It's called TAS, Trademark Electronic Search System. By clicking this link, you will be able to access the website. The website looks like this. It's very simple to use. You can conduct a general search, a wordmark search, good service. If you know the serial number or owner, you can search for it. So if you just want to do a general search, you can put in a word. either in a trademark or products or owners, and they would do a basic search for you. So the purpose of having a trademark is to ensure that consumer gets what is paid for and expected to receive. So it protects the owner against piracy and misappropriation on the market. And so in terms of a trademark infringement, so there are two principles to consider as the infringement of trademark. First is market confusion. So the judges in the court will decide the likelihood of confusion, and then they will conduct consumer survey or study to see if the regular reasonable consumer will get confused by the counterfeit. And then the third is delusion. So, the bad faith as well. Bad faith is also infringement. You cannot badmouth other people's work, and then that will consider as a trademark infringement as well. So the next is delusion. So the delusion refers to behavior that weakens connection between a trademark and a product. And so, like for example, Google and then Xerox. So Google is a name of the search engine, right? But have you heard about people say, "Hey, can you Google these words for me?" And so when you are using Google as a verb, it's a sign of using it as a general, like a generalize these trademark. And then Xerox, the photocopy machine company, had suffered from like people would say, "Hey, can you Xerox this paper for me?" And then so they have to put ads onto magazines and then newspaper to remind people, do not, Xerox is the trademark of a photocopy machine, and please do not use it otherwise. So in order to protect their trademark. Table 9.1 lists the different types of trademarks in the order of the strengths of the mark. So range from the fanciful marks is the strongest because the, for example, Exxon for petroleums and Pepsi for soft drinks, there's no meaning other than act as a mark. And then the arbitrary mark is the second tier. Apple for computers, Tide for detergents. The word has its original meaning, but then it has no meaningful in relation to the goods and the services they are related to. The third tier is called suggestive marks. Examples, for example, Coppertone for suntan lotion, or Burger King for burger restaurant, Microsoft for software for microcomputers. So these words are suggestive quality or characteristics of a good and service rather than describing. And then the fourth is a descriptive mark. For example, American Airlines, Sharp televisions. So these words are merely describe the service or goods on which the mark is used. So these types of mark are often difficult to enforce unless the trademark owner can show that the mark has become distinctive in consumers' mind. And so they have to advertise this very heavily so the second meaning of the mark can be obtained in the mind of consumer. So, for example, Off-White, the brand Off-White has a boots trying to acquire the trademark for walking. Boots, they have a rough road with the USPTO on getting the trademark. And then the generic terms has the least protection in terms of trademark, and oftentimes it's very hard to get a trademark over the generic terms. For example, if you want to trademark bicycle for the bicycle brands, or e-tickets for e-ticket selling platforms, so it would be hard to for the USPTO to grant you the trademark on these generic terms. And design in the US can be also considered as trademark. Here is Air Jordan 1 from Nike. So they use the design like a trademark to protect their shoe designs, and then in 2020 they actually got the Air Jordan 1 trademarked instead of using the trade dress. And so for the trademark infringement, is defined as the unauthorized use of a trademark or service mark, and then on the competing or related goods and service. And trade dress is the protection in the form of IP that specifically protects the look or forms of a product. So as long as the public can recognize the brands from its look. So take a look of this perfume bottle. Can anyone tell me what perfume this is? So if you said it's Chanel No. 5, you are correct. So because its distinct shape and the a bottle design, Chanel No. 5 have been protected. The bottle design has been protected under the trade dress. So please note that the trade dress does not serve as a functional purpose, and it has to be distinctive in its appearance. And then in the context of infringement of trade dress, that is a likelihood of confusion between the parties' trade dress. Okay. And so here is a closer look of Nike's trademark design. So next, we will talk about patent. So a patent is for inventions granted as a property right to the inventor. So the assignee is the entity that has the property right to the patent. And then inventions must be a new, non-obvious, and novel. So in the U.S., among all the countries in the world, U.S. is the only country that granted patent for the e-commerce business model. And for example, U.S. has been granting like a one-click checkout system, or the IBM's credit card swipe as a business model, and then also Priceline's reverse auctions as the patent application. In Europe and many Asian, African, and South American countries, it is almost impossible to obtain the patent on the business method or computer process. They are mostly protected under copyright for computer programming. So in the U.S., patent can be defined as two categories. First is called a utility patent. It may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacturing, or composition of matter, or any new and useful improvement thereof. So the protection is 20 years from the application date. And the design patents may be granted to anyone who invents a new, original, and ornamental design for an article of manufacturing. So noted that the U.S. is the only country in the in the world granted design patent. In the world intellectual intellectual property right organization, they actually call the design patent as industrial design, and instead of coded patent. So the design patent is granted 15 years from the date the design patent is granted. And then this could include the appearance, shape, configuration of the elements, and the decorative component. And then may apply to many types of fashion products such as footwear, eyewear, handbags, and totes. So here I want to show you like Amazon has its patent application for its beehive look fulfillment center design for their drone delivery. The patent was filed, application date is October 3rd, 2017. And then it has been granted as a U.S. patent here. So as you can see, it has a figure illustrates. The truck will go out from the bottom of the building. It will be a round-shaped, circled, like silos look like building. And then they have small windows that they can send off the drone. So other than these, an omnichannel retailer may obtain, for example, software program, for example, Styles, has an automated color processing and selections for the product suggestions platform as a software patent. Amazon, they have a fulfillment center as shown here, and then Nike apply for airbag for the article of their footwear, their shoes as innovative product materials. And so here's a photo of the Amazon drone for the product delivery. Amazon consistently working on the last mile delivery system, and then as you see, 2017 they already have the concept of building up the drone dispatch distribution center, and then in 2024 they already received the permission from the FAA for them to fly their drone for the delivery. Other patent application strategies, if we take a look of athletic wear like Nike and Adidas, they take a different approach. Nike obviously is a US-based company, and then is very popular worldwide. So they don't want to be the targets for the other company take advantage for their brand. So they has applied more than 6,000 design patents, as you can see in the figure here, and to protect its shoe insole, their garments like jackets, pants, or shorts. They also have the display screen design, design patterns. And then while another part, Adidas only secured the 244 design patent with the USPTO. So, of course, that's a business strategy, and different companies may take different strategies in their patent application approach. So next, we are going to talk about copyright. So copyright is also an important intellectual property right that omnichannel retailer can get. So copyright refers to an exclusive right of the author or creator of a book, movie, musical composition, or other artistic property to print, copy, sell, license, distribute, transform to another medium, translate, record, perform, or otherwise used. And in the US, the copyright is protected as the author's life plus 70 years. And if it's a company, there will be 95 years after the first publication. or 120 years from the year of its creation, whichever expires the first. And then the reason I put the Mickey Mouse in here is because in most of the country in the world, like UK, their copyright is protected as the author's life plus 50 years. And the reason that the US has such a long years after the author's life is because of Mickey Mouse. And so Mickey Mouse actually played an important role in the Disney company, actually played a very important role on the U.S. copyright law, because since its creation, Disney has been extending lobbying the Congress to extend the copyright protection every time when it's about to expire. And so here is an article from the Duke Center for the Study of the Public Domain. You are welcome to take a read, and it has a very interesting and comprehensive discussion on the different versions of the Mickey Mouse throughout the years. And then so what is inspired is the Steamboat Mickey Mouse that were first created in 1928. And so this is a very interesting to see how a company and Mickey Mouse has an important role to play in extending the U.S. copyright law. So I hope you find this case interesting. And this is a constitution tree that marks the important people that played a role in the U.S. Law, and the Mickey Mouse is on this tree, and then to see how important it is. Okay, so other things related to the copyright. Next, we will talk about copyright infringement. For consider as a copyright infringement is a use of a work, copyrighted work, without permission or contracting for the payment of a royalty. So a copyright notice should include the following three elements: the copyright symbol, the year of first publication of the work, and the name of the copyright owner. So figure 9.3 is a comparison. So do you think these two shoes are similar? And then the right hand side, you notice that is the New Balance, right? So do you think these shoes look similar to the New Balance shoes? If you feel confused, then probably most people do the same thing too. So actually on the left hand side is Michael Kors pop-in shoes. And then after they launched the shoes, then New Balance brought the Michael Kors to the Massachusetts court. And then in the end, they were able to, so the judge has ruled that a favor to the New Balance. And so Michael Kors has to settle with the New Balance in these copyright infringement. And in the e-commerce part, the fan and hate site is also considered as copyright infringement. Cyber bashing is a term describing the domain name that criticizes an organization or person, for example, PayPal Socks or WalmartBros.com. And then this is considered that copyright infringement of their, and then the company can bring the person to register the domain name to the court. And also, any material published on the fan site, hate site, and news groups may violate the copyright of the creator or distributors of their intellectual property. So one of the famous cases is J.K. Rowling. After Harry Potter was released, their fans actually set up a website called the Harry Potter Lexicon, and then J.K. Rowling brought her fan to the court and then cried in the court, saying that she felt very hurt that for this copyright violation, but then later she set up the Lexicon website by herself. So when it comes to the copyright infringement, a lot of time the other party will be, the defendant will claim that they are using the copyright material as a fair use. So what is fair use? Fair use is a statutory doctrine that promotes the freedom of expression by permitting the unlicensed use of copyright-protected work in certain circumstances. For example, criticism, comments, news reporting, teaching, scholarship, and research, right? And so in the USPTO, the following in the US, the following 4 factors are considered when it comes to evaluating a fair use case. First, the purpose and the character of the use, including where the use is a commercial nature or it is for a non-profit educational purpose. Second is the nature of a copyrighted work, to what degree the work that was used related to the copyright purpose. Third is amount and substantiality of the portion used in relation to the copyrighted work as a whole. So, for example, a book it has more than 200 pages, and then you may make a copy like for 10 or 5 pages, and then that may not proportion-wise may replace the whole copyrighted work. However, if the 5 pages is the most valuable asset in that 200 page book, then the court can decide it still violates the copyright. And the fourth one is effect of the use upon the potential market for or value of the copyrighted work. So that means that by the use of the copyright work, how much markets were actually invaded from the original copyright owner. Okay, so these 4 factors are the main factors when it comes to evaluation of fair use case. So last summary, we have talked about the patent, copyright, and trademark. So I would like everyone to be aware that a fashion product can consider be protected under different types of IP protection. And then the difference between the copyright, trademark, and patent is copyright protects its original work of expression, okay? And then while the patent protects the innovation of utilitarian objects, and the trademark protects the words, phrases, symbols, or design that distinguish them from others. So, for example, these Hoka shoes. So the sole of the shoe can be protected if it's a special material. Then they can be protected under patent. The whole appearance of the shoes and the color combination can be protected under copyright or design trademark. The name Hoka as a brand can be trademark protected. Okay, so I hope this makes sense to use multiple intellectual property to protect the right. In table 9.3, we have listed different kinds of intellectual property rights protections in the United States, and the subjects and the scope and the advantage and disadvantage of utilizing these rights. So case study. In this chapter, the case study is a case that Nike sues over unauthorized Saturn shoes. In year 2021, Lil Nas X, a Grammy-winning rapper, released the Saturn shoes in collaboration with a company called MSCHF, and then which is art collective based in New York to promote their latest music video. And then so basically they inject like a blood red ink mix into the airbag in here, and then they put a pendulum here, a bronze pentagram shaped charm to the shoes, and then immediately that Nike brought the Lil Nas X and the MSCHF company to the court. So these actually involve a lot of criticism, and then so it was they released 666 pair of altered Nike Air Max 97s as their Saturn shoes. Here is a comparison of the original Nike Air Max 97, and these are unauthorized Saturn shoes. You can see here. And then someone thinks on the social media thinks that actually is a fan of their religion, and then they thought this is a Nike official collaboration with the Lil Nas X, and then so they start to criticize Nike on the social media, and so that's why Nike very fast brought the company into the court, and then later they settled. So here are the discussion questions I hope you can think about. Do you believe these shoes are covered by the First Amendment as a freedom of speech, or do you think they can clear as a fair use? So do you think if you are a fan of Nike, would you buy these shoes? And then how much creativity is too much creativity in your opinion? So, all right. So to conclude in the discussion board 8, I would like you to think about what strategies can omnichannel retailer employ to balance data-driven strategies with the need to protect consumer privacy. And then how can they effectively communicate their commitment to privacy to build trust and foster long-term customer loyalty? Please make a post and then reply to 2 other people. Okay, that's it. I hope you enjoy Chapter 9.